May I also request Mr. Shyam Devan, President-elect Law Asia, to be on the dais, please. Can I request Ms. Rachna Srivastav to give a bouquet to welcome our chief guest, Honorable Mr. Justice Dinesh Maheshwari, please. Where's the bouquet? 2 minutes, I think they're just bringing it. Rachna ji. May I request now Ms. Anandita Pujari to give a bouquet to our Attorney General. Thank you. With the permission, can we commence the proceedings? I am obliged. So, I request Mr. Amarjit Singh Chandiok to please come on the dais and make his welcome address.
Honorable Mr. Justice Dinesh Maheshwari, Judge, Supreme Court of India. My dear, the learned Attorney General of India, Mr. Venkaramani, President, Bar Association of India, Mr. Prashant, Mr. Shyam Devan, President-elect Law Asia. I have dignitaries from India and abroad, Advocate Generals, other dignitaries. Welcome you all to Bar Association of India's New Delhi International Rule of Law Convention. We at Bar Association of India, I'm proud to say, start from Ladakh and go right up to Kanyakumari. Our executive committee has members from all over the country. We already have associations with many other parts of the world. The dignitaries from outside speak for itself, that they've come all the way to be with us. There are participants from many parts of the country. We welcome you all. The convention will take us to the new views that we need to discuss. It will take us to what today business requires to look at. It will also look at why should not we be human first, in whichever capacity we are. We'll look at what are the dispute resolutions that we have today. I'm sure these sessions would help us debate on it, discuss, and probably lay down guidelines for our future. And I'm sure with all of you participating and the eminent panelists coming up, we'll make a great success of this convention. In the early morning, let me thank you for being here and welcome you all to start this new Rule of Law Convention. Thank you very much.
Now may I request Mr. Shyam Devan to give his address.
A very good morning to each one of you. Justice Dinesh Maheshwari, Judge, Supreme Court of India, Ms. R. Venkatramani, Attorney General for India, my distinguished friends on the dais, Prashant, Amarjeet, Mr. Chandiok, distinguished ladies and gentlemen who've traveled great distances to be here, law students, young lawyers, may I add my couple of words of welcome to each one of you, particularly those who've traveled distances. Welcome to New Delhi. It's a wonderful city in many, many respects. I think some of you must have also already tasted a little bit of the architectural splendor which the city has to offer. Ancient architecture, medieval architecture, and wonderful contemporary architecture as well. We have some splendid gardens. There's Lodhi Gardens, very close to this venue of ours. There's Sundar Nursery. I commend each one of you to probably take out a little bit of your time and visit the wonderful gardens that Delhi has to offer. There's lots in terms of varieties and options for Indian food, and please don't miss on that experience now that you're here in New Delhi. The beginning of summer, and this is a slightly divisive issue which I speak of, is the beginning of the mango season in India. So each one of us has our great loyalties to mangoes, which are a delicious fruit from different parts of the country. My favorite is Alfonso or Afus, which comes from the Konkan region on the west coast of India. But I suspect that everyone on this stage and probably in the audience has a contrary view and a favorite which is sort of regional specific, because I suspect that our tastes develop as children and then we continue that loyalty throughout our lives. The term Vasudeva Kutumbakam is a Sanskrit expression, and this Sanskrit expression, essentially drawn from an ancient Upanishad, one of our Vedic texts, speaks of the world being a single family or one family. And this is, of course, very resonant, I think, with today's age when our problems span not just the nation state, but across jurisdictions, across the planet. And perhaps there's a lot to learn, and I'm sure the speakers will expand on this theme as to how the current solutions which we fashion need not be or cannot at many, many levels be local solutions. And the reason is that the world is flat. Technologies are being applied, used, sometimes misused across the world. And we have a situation, therefore, where solutions have to be found as if we are a single family. And here, of course, the concept, I think, it's sort of pregnant with philosophy. It's not just across jurisdictions in the form of physical jurisdictions and nation states, but it's perhaps also the notion of a single family across species, across situations where we wonder, and I mean there's deep-rooted philosophy in this part of the world, where what is traditionally considered as inanimate, whether it is mountain ranges, whether it is flowing rivers, whether it is forests, all of these in parts of our country are worshipped. And perhaps this key phrase for our conference strikes a resonance or some sort of a chord with even uniting solutions with regard to not just across the world and multiple jurisdictions, but possibly across species as well. The theme also has a resonance to the United Nations Sustainable Development Goals, which you all know must by 2030 be adopted and attained to the extent possible. And SDG 16 is particularly of relevance to us because SDG 16 calls for peace, justice, and strong institutions. And I commend the organizers of today's conference for having melded the theme of the conference with this global agenda where we seek and work towards strong peace, justice, and strong institutions, which obviously includes promoting the rule of law at both the national as well as the international level. I think there is a huge amount of work here to be done, not just at the level of individual lawyering, but also a role for bar associations. And I can see several leaders of the bar from several jurisdictions present at this conference. And I commend you to sort of put on your thinking caps as to how we, as members of the bar and as members of the organized bar, can contribute towards building stronger institutions to attain this SDG 16 goal. There is a great jurist of this country, was a senior advocate who argued some of our most influential cases, Mr. Nani Palkhiwala. And last night when I was preparing a few points for this talk, I happened upon an article which he wrote in January 1977 on the retirement of one of our great judges of the Indian Supreme Court, Mr. H.R. Khanna. And this is what he said: "So long as there is a judiciary marked by rugged independence, the citizens' civil liberties are safe, even in the absence of cast iron guarantees in the Constitution. But once the judiciary becomes subservient to the executive and to the philosophy of the party for the time being in power, no enumeration of fundamental rights in the Constitution can be of any avail, because the courts of justice would then be replaced by the government's courts." I can state with mild confidence and a tinge of optimism that in India at 75, since that's the number of years since independence, we continue to have courts of justice and not government's courts. Nevertheless, it remains a constant endeavor on the part of citizens and their lawyers to widen the door of liberty where it is being shut, to stick a wedge into statutes that concentrate state power, and to push back against the intolerable epidemic of statutes that discard the presumption of innocence. In championing the rule of law, we must value distrust. Unless we retain a healthy distrust for the state and its organs, we may slip back, as we did in India during the spurious emergency between 1975 and 1977, and slip into a dark abyss. With a seventh of humanity in this nation, that would become a tipping point as far as planetary freedoms and liberty is concerned. So building institutions through the rule of law will mean not just an independent bar and independent judges, but also an informed, educated, and independent frontline protectors, namely the bureaucrats, the police investigating our cases, and of course the integrity of our prosecutors. So there's a huge amount of work to be done in terms of attaining the SDG 16 goals. And my final point is, I was introduced as President-elect of Law Asia. I have mentioned this to some of you as we met yesterday and this morning. There is the Law Asia annual conference in Bengaluru this November, between the 24th and 27th. And I request all of you to enrich yourself, not only from the deliberations of this particular rule of law conference, but also the event which we are planning in November. Thank you very much, and do enjoy the mangoes.
Thank you, sir. May I now request Mr. Prashant Kumar, the President of Bar Association of India, to give his address.
Honorable Mr. Justice Dinesh Maheshwari, Judge Supreme Court of India and Chief Guest for today's inauguration ceremony, Honorable Mr. R. Venkatramani, Attorney General for India, and you know, he is one of the rare poet Attorney Generals of India. He is known as much for his poetry as his legal acumen. And my colleagues, Shyam Diwan, Mr. Chandyok, and Amarjit Singh Bedi, and all the foreign delegations, India is having G20, and the Bar Association is having its own G20. We have 20 countries represented here. And it is due to all of you who have taken the trouble and initiative and honored us by accepting our invitation and coming here. And I hope you will have good time here, good deliberations, and all of us will leave these 2 days enriched and learning a new few things and knowing about each other more, making more friends, because that is how the entire human society proceeds further, by forming relationships. Now, what is rule of law? There are several definitions, but ultimately, rule of law at the core is having systems which order human relationships and transactions at the state level, at the international level, and how all these relationships are conducted harmoniously and for mutual benefit. So at the state level, this is the institutions of governance, as Shyam has already spoken about, that UN has the agenda, SDG 16, to strengthen the institutions, especially relating to the justice. Now, the other aspect which Shyam has also spoken about is whole world being a family, Vasudhaiva Kutumbakam. And that is where the conception of rule of law, which is today measured, applied, and thought about mostly in terms of nation states, transcends the nation states' boundaries and has to come to apply to the international relations, how humanity, which is now borderless. You have visa norms, you have this thing, but now modes of travel, increase in business, trade, cultural interactions is creating a unified humanity. And that's why these core values of rule of law must also apply how internationally the relations between the people to people, and the nation states are ordered. Now, at New Delhi, when we thought, because most of the organizations, national organizations, international organizations like International Bar Association, which is represented here, and Union International, this Advocates, which is represented here, Law Asia represented here, all organizations have rule of law at its core objective. So why we are making this kind of a dialogue in New Delhi? The spur for this came from two ways. One, we find that whenever there are dialogues around rule of law at various international fora within the legal community, they always measure that how the rule of law is performing or thriving or being undermined in different jurisdictions, but the standards and the outlook and the standpoint from which all the assessments are made are from Europe, from United States, where we have history of centuries where these institutions have formed and got roots. Then we talk about Global South. Global South, last 50 years, like India, 73 years, have come out of colonial rule, have come out and broken the isolation. The countries in Africa, in Asia, in Latin America, and in South America, all these countries, they have to have an organic growth of institutions. You just can't have institutions which have performed well in other parts of the world, but all those institutions, even brought in to the systems, they have to then grow in consonance and in harmony with the ethos, with the culture of those jurisdictions. and also the historic circumstances. So that is why we thought it will be worthwhile that we start talking about rule of law, we start having conversation about the rule of law, where we share our experiences, not just our successes but our failures, and we learn from that. So that is the spirit with which we have invited you all to start thinking from this point of view, how rule of law should apply to us, what we have done with the institutions so far, and how should we proceed further. Now, when we talk about global indexes, comparative, how rule of law is there, and Bar Association of India also works with World Justice Project, which brings out rule of law index. But some things which, all these indexes do is to have a specialized criteria and assessment. Like when we talk about India, we are somewhat in a middling position in terms of the index. But if you keep the index away, with all the problems, with all the issues which are there, which are bound to be in a country which has so many languages, so many religions, so many, federal structures, so many state governments, and so many challenges of poverty, so many challenges of bringing people out of the poverty. So in these challenges, there have been some deficits. There is a legal system, a justice system, which is not able to cope with a huge number of cases which come to the courts, and that is what is counted as something which impacts the rating of the rule of law in India. But if we look at the other side, India has been an uninterrupted democracy since independence. Every election has seen a peaceful exchange of power, transfer of power, at federal level and at state levels. Our election commission has performed wonderfully. Our judiciary is one of the strongest judiciaries in the world, exercising the power of judicial review. And that was demonstrated in 2014-15 when the Supreme Court struck down the law on appointment of judges, a law which was passed by almost unanimity of the Parliament, but it fell foul in the estimation of the Constitution bench of the basic structure of the Constitution, and it was struck down. So perhaps it is one of the most powerful judicial independent institutions in the world. Yes, of course, it is the quality of jurisprudence, the pendency, other challenges are there. But on the other hand, if you see generally about India, and I want to look at this pendency from a different point of view, just see the resilience of Indian people and their trust in the institutions, that despite the years and years of pendencies, people still go and take recourse to the institutions. They want to go to courts to have justice, and they patiently wait for it. They know it's a big country, the system is overloaded, but nobody goes on the street. The society remains peaceful. And that is what is the glory of India, because we have not only adopted the modern institutions of governance, a constitution which is very elaborate, but also we have melded it with our own cultural ethos, with the values of Indian people, and how they have for centuries lived together and assimilated every race, every this thing. India is perhaps one of the countries which has allowed all the races and people to come to India. They were welcomed and never forced to change their religion or their ethos. They were provided with environment to retain their culture, retain their religion, preserve their cultural practices. So that is how it is the centuries traditions that have sustained the rule of law and the institutions here, not just the structure of the institutions or the legal frame behind it. So this is how we find that each country has its own unique ethos. Like we have South Africa here, and after apartheid, dismantling of apartheid, there was Tamil War, and the political stability came. One of the ideas was whether in Sri Lanka for the Tamil and Sinhala reconciliation, the South African model can be adopted. But ultimately it was thought that the South African model came from the very unique tribal cultural ethos of South Africa, and it may not be possible to implant it, lift it and implant the model here. So that is what we are making an endeavor. We want to understand each other, and we want to feel proud, encourage each other that we develop systems. They may be deficient somehow, they may be having the challenges, but having conversations, having understanding, and making them in the image of our own cultural identity, our own history, our own values, and our own priorities. And lastly, I will say that whatever the other things are, India's biggest success lies that from 2005-06 to 2020-21, in the World Poverty Report, India has been successful in bringing 473 million people out of poverty. And that is what I say is a symbol of a very healthy rule of law. Because without justice, without social equity, none of these things could have been possible. So as we always strive and continue to strive to improve ourselves, to face challenges in more robust and bold manner, analyze our own deficiencies, which is a must to improve ourselves, but at the same time, we must assess our core strengths, and we should bind our core strengths with our priorities and work with other friends and see that world becomes a better place in terms of application of the rule of law, its core values and principles, which ultimately promotes human prosperity, human well-being, social equality everywhere on this planet. Because ultimately, with the water, with energy sources, everything which is finite, there is going to be more challenging scenarios when the populations are increasing, climate change is there. We have to learn to live together. We have to see that everybody gets what they deserve. Otherwise, like the pandemic, that COVID virus spread in no time all over the world, these tendencies where populations who are deprived, who don't have means, who suffer want, who suffer deprivation, that can also spread as a contagion throughout the world. And we know even in developed countries, we have some symptoms whenever some benefits are taken away, the rule of law breaks down. There is violence, there is challenge to the authority. So we have to think together, we have to work together, and we have to take it forward. Thank you very much.
Thank you, sir. I'm sorry, I've just been told, so there is lighting of lamp. May I request Honorable Mr. Justice Dinesh Maheshwari and our Attorney General please to come and light the lamp, and all our members on the dais please come and assist that.
Lighting of the lamp is an Indian tradition related to knowledge, because the knowledge is ultimately the light of knowledge drives away the darkness of illiteracy, the darkness. So that's why lighting of lamp is always carried out for every auspicious function, to remove the darkness and to bring light.
Thank you. Now may I request our guest of honor, Mr. R. Venkataramani, our Attorney General for India, to give his address.
What a wonderful initiative Bar Association of India has set in motion. On behalf of the Indian legal fraternity, my friends on the dais and my very esteemed friends here in the audience, Mr. Vaidyanathan, Mr. Naganan, the Advocate General of Kashmir, Mohit Mathur, and many others who are part of this think tank of India, if we may call it, are here to welcome people who have traveled from all over the world. Way back in 1783, two convicts who were convicted and imprisoned, sentenced to death in England, by a chance of destiny, were transported to New South Wales. And a husband and wife, they got married while they were in jail. And it so happened, instead of being transported to America, they were transported to New South Wales. And New South Wales became the first convict colony of England. And when these two persons who got married in jail, and the woman gave birth to a child, and fortunately they traveled together. So they landed in New South Wales after about 8 long months of journey. They found that the belongings of this couple, which included a lot of charitable contributions gathered in England, did not reach New South Wales. And they had a problem. And where did they go? The first civil court and a court to look into the wrong of a captain of a ship was convened. And the court ordered in favor of the return of the belongings of these two couples. And a wonderful book is written on rule of law in a penal colony. So we have those examples of human civilization wherever they landed, to lean in favor of and to clutch those very important elements of human civilization, namely rule of law. Why I cited this penal colony is, I'll come back to it a little later. Is the world on fire? Have the promises of free enterprises in collaboration with science and technology to generate hitherto not witnessed social resources for being accessed by all peoples, fallen into traps and challenges, and thus seem open to question? How far an experiment in fusion of extreme political control and regulated economic freedom as communist China has embarked be replicated at all as the answer to social evolution to rid of inequalities? Are we to ponder new forms of collective governance where freedom, creativity, and innovation are the basic driving forces of human flourishing, will and can coexist with claims for equal regard in all respects and equality in life pursuits? Thomas Piketty argues recently that we need to talk about a new way of going beyond capitalism, a new form of socialism, participative and decentralized, federal and democratic, ecological, multiracial, and feminist. 100 questions confront us in unraveling answers to these and connected issues beyond quarrel or debate. The very unique endowment of humans in explaining the world through its experiences is also the treasure trove to be wisely handled. Do we need more and more of political regulation as frontiers of our freedoms expand? Or should we simply manage alliances with technology to have answers to these subjects? If power is what is generated by in collectivities, in consent or coercion, and as said, therefore, has protean and diverse forms and faces. Power is thus what we politically experience, whether as order, democracy, authority, subordination, capacity, possibility, or containment. Powers without their glaziers. This choice is had us as hard as we cannot forsake hunger and inequality. The imperatives in choosing sustainable life meanings and practices is an urgent question. Similarly, about technology and its redemption promise. A perspective study puts it like this. 4 pictures of law are considered. 2 are traditional pictures, law as order and law as just order. And other 2 are prompted by technological disruption of law. Law as governance by machines and law as self-governance by humans. Tim Berners-Lee, who is credited with creating the World Wide Web, said this, I quote, "As we are designing the system, we are designing society. Ethical rules that we choose to put into the design impact society. Nothing is self-evident. Everything is to put there as something that we think will be a good idea as a component of our society." I quote. Professor Ursula Franklin argues in her book, The Real World of Technology, thus, technology is not the sum of the artifacts, or the wheels and gears, or the drains and transmitters. Technology is a system, but it entails more than its individual material components. It involves organizations, procedures, new words and equations, and most of all, is an agent of power and control. Quote, "Are we going to be a world without mind, going about our lives in isolation in the private worlds of technology and public transformation of our life, social and economic order, without thoughts on equality and equity, and resigning to solutions that may come from inadequately informed governance institutions and judicial reach? All these are rule of law questions beyond traditional matters such as democracy, independent judiciary, and accountable watchdogs." Historians hold mirrors unto us as if helping us to learn about a protean past and chart our destiny on this planet based on lessons drawn from the past and across civilizations. Whether it is dialectical materialism or any other school, the offer assists in planning our future. Since we cannot have a time travel machine, unlike the time machine of H.G. Wells, capable of going back into our past and traveling into the future, we look into as much as history can teach us. Recent history in the post-Soviet Union era, the constitution-making exercises in Eastern Europe, alongside the ethnic clashes there, the upheavals in Islamic territories, including the US presidential debates around both the Bush and the Trump elections, valuable lessons for taking stock of the importance of the rule of law and the debilitating factors such as culture and policy. In the sense, history is one tool of rule of law. Each age of our shared history has organized forms of governance, of being together, while growing differences and distinctions. In different ways, the superior binding relevance of some code, law, morality, dharma, and so on has been emphasized, entailing the supreme value of governance under some code of conduct. All nations and civilizations across geographically connected cultures bear this feature. Volumes have been written on how violence has been the way to resolve multitudes of differences or invoke social, geographical, religious hegemony. Optimists, however, predict that violence as the means of going around a problem is on the wane. We can attribute this significant decline in violence to many factors: the decline and end of colonial occupations, the decline and end of religious colonization or hegemonical ventures by force, the decline and end of national wars, the emergence of the idea of constitution and representative democracy, the emergence and entrenchment of ideas of right that can be enforced through impartial tribunals, particularly human rights, civil, political, social, economic, and cultural. And maybe we can add more to this list. 2 propositions are made here. One, that rule of law is the antithesis of all coercive authority, which impedes or interferes with the profundities of life and liberties. Two, that unlike revolutions witnessed by Europe or elsewhere, the non-violent revolutions or the rule of law is the more nuanced genius of human prospect on this remarkably ordered earth. It does not matter the rule of law is hijacked by both sides in a debate, as it happened in the case of election debates surrounding the Bush election. The attempt made here is to ask questions and spread them, then drawing a final catalogue of checklists for the rule of law. Therefore, can there be one all-embracing concept, definition, or comprehension of the rule of law? Is the rule of law evolution an amalgamation of several political and social ideas, ultimately tuned to limit and tame all arbitrary power, private or public, in all their emanations, manifestations, and practices? Is it more closely connected to the institutionalization of all social and governance processes so that justice, equality before the law, and accountability to power are secured by rules and made through community participation and publicly enforced? Why do we need the thin and thick varieties of rule of law, and what do they conceal? Political ideologies dressed in new clothes? On the thin conception, note what John Rawls, among others, says. On Rawls' view, I quote, rule of law is simply the conception of formal justice applied to a legal order or a system. Formal justice, in turn, is a thin, non-moral principle of reason addressed to rational persons to regulate their conduct and provide the framework for their cooperation. As to the thick notion, note what F.A. Hayek holds, I quote, when you obey laws in the sense of general abstract rules laid down, irrespective of their application to us, we are not subject to another man's will and therefore free. Because the rule is laid down in ignorance of that particular case, and no man's will decides the coercion used to enforce the law. The law is not arbitrary. Quote. Several statements on the high ground of law and subjection of all people and relevance of rights in securing them have been made in the past. Remember the famous statement made by H.L.A. Hart that where there is law, the human conduct is made in some sense non-optional or obligatory. All such statements are made in the context of diverse historical backgrounds and social orders. Is it not that they are either partial or incomplete for current universal global reception in view of the neoliberal economic spread and technological-driven globalization, which poses several unprecedented global and local challenges? The coalescence of the nation-state with the market state, the domestic and international management of the new avatars of global interactions, call for multiple blueprints of action. The growing inequality in terms of accessing resources, socially generated, namely economic and livelihood resources, education, culture, justice administration, and health, and their entanglement with the rule of law is again a subject of deeply divided opinion. Or is it that we need to acknowledge multiple conceptions of rule of law with common denominators and additional layers of significance? The following observations apply the quick critique of formal proposition, the rule of law. The more the theory of the rule of law is desubstantivized to embrace only those institutional forms that have such values associated with the formal rule of law, the more likely it is that the formal rule of law will receive its due. On such a politically and neutral conception, far more people from all segments of the political spectrum can be enlisted to support the rule of law and to criticize departures from it. From the aerial scan of what is attempted above, I wish to say that only through a non-violent social processes that are closely affiliated and converging in the rule of law that can be proclaimed a truly fair social order, where human wealth of the cooperative production of all is the wealth of the community for all, where property as a social relationship will be a matter of resource management and not of unfettered control of being and life of others, where freedom of thought and conscience of the individual will be valued as a measure of the community's ability to promote and manage individual liberty, and where individual liberty will be the common quality of humanity and will not vary with chances of birth and status as it obtains today. Thus, there is an intense inquiry and search for human fulfillment and well-being that can be attained through higher and legitimate levels of governance and consistent with freedoms in all dimensions of life. Freedoms, when self-nurtured and internally organized, attain nobility. When freedoms seek to run riot, hissing dangerously at any regulation, governance gets debilitated. So also, when governance becomes a juggernaut wheel or yields to sinister interests, it is cancerous. Adjectives are therefore sometimes added to supply emphasis on the quality of governance, and thus we talk of good governance to mark some distinctions. It is not enough, as perceptively stated, to offer rule of law assistance standard menu. It is instructive to read critical statements on what is referred to as the rule of law assistant standard menu. The menu, according to the scanning eye, includes reforming institutions, judicial reform, strengthening legislatures, police and prison reform, etc., rewriting laws, modernizing criminal, civil, and commercial laws, upgrading the legal profession through support for stronger bar associations and law schools, and increasing legal access and advocacy through the support of legal advocacy, NGOs, law school clinics, and so on. The rule of law is not something that exists beyond culture and that can be somehow added to an existing culture with a simple expedient of creating formal structures and rewriting constitutions and statutes. In its substantive sense, the rule of law is a culture, and the human rights law and foreign policy communities know very little and manifest little curiosity about the complex process by which cultures are created and changed. We are called upon to defer ecology dictates and therefore explore more seriously than ever sustainable development. Deep debates on development have encountered what constitutes indices of development and the new global scales of uneven human standards of life, while representative democracy and the political power competition seem to inject periodic vigor into the lawmaking processes, social and cultural factors also try to capture a good bit of the show in many countries. In a nutshell, we seem to be at crossroads. Either we hold that rule of law debate is no longer confined merely to controlling arbitrary power through the supremacy of law, repeating the importance of equality and cataloging rights, or we stand by the emerging demand that rule of law must get into fundamental questions of political processes through which rights, duties, expectations, and needs are debated and administered, constitutions abided by, discretions and public policy choices are open to correction, and that no dispensation of any sort are made under cover of assumed wisdom of any system of economic ordering. We will not be merely discussing impartial courts, fair trials, known laws enforced through known and published procedures. We may have to march ahead of propositions on the rule of law drawn by institutions like the World Bank, though not turning them down. While I wish to read the rule of law evolutions propelled by the instinct against non-violence, amongst other factors seen above, I also wish to understand that a social order, which is blind to the ideas of right and duties of each human being, moderated by every age, is a non-rule of law social order. Each of us creates, makes, sustains, or annihilates individual and collective lives, social orders, and the world that sustains us. For the rule of law, what would matter is how these functions are enabled, injuncted, and regulated without sacrificing creativity and innovation, and blended with equality and equal regard for all life. The womb of Magna Carta carried the seeds of rule of law partially. It awaited more motions towards democracy before economic liberty became a crucial factor in the rule of law. Only the great lessons from the fields of blood, strewn by human violence, have told us that the highways to justice are to be learned from non-violent rights and duties conjunction, and the ladders of rule of law are to be built brick by brick. Again, while it is invigorating to read great minds like Professor Upendra Bakshi or an American academic like Professor Brian Tamanaha, drawing our attention to the unlit or ignored corners of our focus, it seems that we need to tie together seemingly unconnected threads, namely substantive versus formal theories, social justice versus freedom and the market states, culture and obedience to law, globalization and the surge of technologies, and so on. We notice in a way, earlier, the rule of law is not about the static affairs of governance within a static framework. It makes sense to talk about the movements of both people and governance towards qualitatively superior functional parameters relating to matters such as community participation in governance, access to justice, and equal application of laws, non-arbitrary criminal law and prosecution, accountability of all public institutions, freedom of expression, regulatory institutions, and their efficacy, corruption, and so on. We thus say that it is not mere stability of governance that symbolizes the rule of law, but the distribution of power and normative dispersion of all socially generated resources. It will make superior sense when we constantly embrace novel approaches to dying systems or do not fetter our norm-creating abilities by the treadmills of the past. All revolutions, however rhetorically grand, have disabled themselves by post-revolutionary aberrations, by ignoring even the basic rule of law norms and burying the instincts of truth and justice. The dogmatic belief in superior ideological narratives, namely socialism or unregulated markets, has shown the yields sufficient strength for all governance. The profound word coined by Gandhiji, satyagraha, encompasses many shades of meanings and can marry well with rule of law. It's an appeal to people and governance to be ever in search of truth and justice, and what more can be closely engaged to these and the rule of law, understood as the non-violent evolution of social orders. Since Prashant mentioned to me about partly being a poet, during this lockdown when many of our minds were closed and within limited frontiers, a few thoughts which came to my mind. I penned down, I thought it may be of some symphony with what you're talking about, and with your permission, let me read it. The title is, Why Are You Waiting? Why are you waiting? The long arms of the clock never stop ticking. Roll up your bed with stains of the past. Close up your lens with lines too dark. Close all the books so dense in the libraries of your mental shelf. Shed all the truths you learned in divisions kept us for too long. Why are you waiting? The leisure you had in the past is dead. Few are in comforts, many are in pains. All your thoughts and codes of rules, which worked in paces slow and sloth, or in trial before a court too strong. Equal all, we cried a lot. Equal all, we wrote a lot. Equal all, we thought a lot. In leisure, we sought answers a lot. Nature, God or what you may, is drawing lines on what you can. Nature, God or what you may, is showing holes in your thoughtless spots. Law and justice, goods and markets, fair in new scores, shared in new ways. Looking back, you dare not do, to rewrite old ways in phrases new. Why are you waiting? Ideologies and histories old will tell you all old is gold. Mind be young, mind be free, mind be strong, and be a midwife of new songs. Race and caste, and all those wares which choked our nostrils and choked our lungs, are Bronze Age brittle mental wares. Rewrite your rules, rethink your ways, relook your thoughts, reload your minds. Why are you waiting? Thank you for all your attention.
Thank you, sir, with the poetic ending. Now may I request our chief guest, Honorable Mr. Justice Dinesh Maheshwari, to give his address to us.
A very good morning to all. It has been a a wonderful and a sweet start of this particular program, where Mr. Sham Diwan started with indicating the sweet mangoes to all of you, introducing. But as a senior lawyer as he is, he can simply put a proposition and leave everything else for the judge to decide. And the judge, as I am, so I asked him, where is the sample and where is the proof? So I hope, if me not, all of you will get not only the sample, but real sumptuous treat here, the Indian fruits, which include not only mangoes, as Mr. Diwan is fond of. There are much of sweetness, not only in fruits, but in several other features all around. The country that is India, that welcomes all of you with warm hearts and all sweetness. When Mr. Diwan was talking about mangoes, I was reminding myself about the season of pineapples in Far East Meghalaya. So, well, there are varieties available in the landscape of this country. Similarly, so far as the principles and the conceptions of rule of law is, and the global order, the global governance order centered on humanism and values and principles of the rule of law and anchored in strong, independent and efficient legal and justice systems. That is the theme framed of this convention today, based on the concepts, the fundamentals of Vasudhaiva Kutumbakam, the basics of the Indian ethos, believing in the world to be one family, and rest all follows and flows from that alone. There was a ceremonial lighting of lamp. It's another fundamentals of the ethos of the Indian society is stated in the catchwords Tamso Ma Jyotirgamay, and it means take me from darkness to the light. That is a prayer, that is a fundamental prayer. What we mean to say, what we mean to pray is that we keep on proceeding towards a better order, whatever are the challenges, whatever is the darkness. Thank you. Mr. Prashant Kumar indicated that we have the delegates from 20 countries here. While we welcome all of you, thank you. This year when India is hosting G20, there are quickly several of the 20 things come to our mind, which include the conversion of a relaxed game of cricket from test matches to T20. And with that, if you just pause, and as was being indicated by the learned Attorney General for India, 2020, the year 2020 had been an year of challenges for the entire humanity, for all of us. An unknown enemy, unseen enemy, had attacked the very existence of the humanity. But we all know the world stood together combating something called the COVID-19 pandemic. The adversities were manifold, the challenges were manifold, but out of every challenge, the humanity came out stronger than before. So, 20 has several lessons for us, and 20 gives us very many possibilities. While welcoming the delegates from the 20 countries, I'm very sure this particular convention is going to go a long way in redefining our thoughts as regards an inclusive global order where even the terminologies of globalization or glocalization, they would be the things of the past, and we would be proudly saying to ourselves only the fundamental phrase, that is Vasudhaiva Kutumbakam. Friends, several things you would be discussing over the time in this convention for these 2 days as to how to integrate ourselves and then how to march ahead. And that is obviously going to have a focus on the economic activities. And coupled with that would be interwoven the activities of dispensation of justice, because dispute resolution would always, the arising of dispute and then resolution of dispute will always remain a part of the requirements of any progressive order. When we talk of rule of law, there's several angles to that, several aspects of that, the fundamental theories of that, as were indicated by the learned Attorney General. And we all students of law keep on admiring those theories, how they have developed, and we keep on developing on them. I'm not here further to add on to that. You are going to discuss about those theories and how we go about further on that, but want to underscore one particular aspect with reference to, in the Indian, particularly with reference to the working of the Constitution of India and with reference to the Indian context, which definitely would be a guiding factor for appreciating as to how the rule of law, and for that matter, dispensation of justice through the adjudicatory mechanisms, particularly the courts, and of course the other mechanisms which are indispensable now, is fundamental to maintaining the rule of law. An example, friends, as it was being indicated by preceding speakers, about the basic structure doctrine that was evolved by the Supreme Court of India, particularly dealing with the questions relating to the validity of any amendment to the Constitution of India by the Parliament. It's a wonderful study for the students of law, for all of us, that the basic structure doctrine was evolved starting from Keshwanand Bharati, but interestingly, out of the 7 instances when basic structure doctrine has been applied to disapprove a constitutional amendment by the Parliament, at least 5 times out of those 7, it relates to judiciary, judicial review, or independence of judiciary. Keshwanand Bharati, Minerva Mills, Sambhamurthy, essentially relating to judicial review. The Supreme Court did not approve any tinkering with the powers of judicial review. NJC judgment was just now indicated, again, that related with fundamentals of independence of judiciary. L. Chandrakumar, another decision, plenary powers of the constitutional courts, sought to be tinkered with, not approved. Even the other decision of Keleho, although the constitutional amendment was struck down on a different ground, but that also related with the powers of judicial review. It has been one instance where the free and fair elections were in question, that the basic structure doctrine was invoked, and else, even when Parliament is otherwise allowed to amend the Constitution as it deems fit, as requires the necessities, when it comes to anything related with dispensation of justice and adjudicatory mechanisms, well, anywhere anything which is sought to deprive the citizens, sought to deprive the society of free, fair, independent judiciary has been frowned upon. Another unique feature, my learned delegates from the foreign jurisdictions being here, I am tempted to indicate. Another unique feature of the Constitution of India is not only the fundamental rights of Part 3, but very interestingly, taking recourse to the court in the case of violation of fundamental right is itself a fundamental right. That is Article 32, the students of law are aware of that. But elevating the right to relief in the violation of fundamental rights, elevating that right itself to a fundamental right is a unique feature. And that is how we can be absolutely sure that rule of law remains fundamental to the Constitution of India, in the sense that any attempt at any violation or any tinkering with rule of law is going to be dealt with by the systems and the mechanisms provided. Friends, mango, as I'm tempted to repeat it again, was being talked about. In India, mango is considered to be the king of the fruits. Maybe Mr. Sham Diwan might be finding it troublesome. Anyway, but it's a treat for all of you, I'm sure. Mango is regarded as king of the fruits. The point is, king in the concept of the civic society, the sovereign, the ruler, whosoever be the king, the concepts had been fundamental in our country, India, that even king is subject to the law. He is not above the law. Law is above even the sovereign. So the rule of law, even in the context of the king, has also been ensured, maintained. Rule of law takes its different shapes according to what is required, according to what at a particular point of time the social order needs. The concept always remains that there are principles. There are principles which are applicable across the board to everybody, irrespective of his status or positioning in the society. Friends, principles have evolved. The principles are evolving, and now with the new global order, where boundaries, so far as the nation's boundaries or any boundary drawn on the globe, have become redundant, are becoming redundant. In this world order, for the purpose of proper progression of the humanity, fundamentally the human beings themselves, the trade, the commerce, and then taking care of the challenges like the climate changes, or these days the cyberspace challenges, the cyber crimes. What remains fundamental in ensuring the rule of law prevailing to any particular smaller unit or to the largest unit of the globe is our commitment, the commitment of the human beings to the principles which are fundamental to the maintenance of the civic society. The exact words rule of law are not found in our constitution and would be less found in other constitutions also. But the concept remains implicit in our constitutional provisions also. The Constitution of India envisages power and authority flowing from the Constitution itself and then distributes these powers among different organs of the state. This again ensures that there is no concentration of power. As I said, it is reflected in the judicial review powers also. Now, coming to the international and the world order, there are two specific categorizations. First is the international law by itself. It could be termed as international law proper and is a rule-based international order. This rule-based order is already in existence and it guides the interactions between the state. The second, and perhaps the interesting categorization, would be the expansion of rule of law in this globalized world, which takes into account the evolving conceptualizations across jurisdictions, which has been described as law diffusion and reception. Given that there are so many emerging areas of law that would require a cross-comparative approach, and also considering that the nature of crime has moved beyond borders and jurisdictions, there is need for the rule of law to transcend the national boundaries. In these areas of concerning arbitration, trade law, environmental law, cybersecurity, now there is an emerging need for a translational approach to the rule of law. And in that context, India is playing a vital role in shaping this discourse and has the potential to take the things forward and further to ensure a well-meaning and a constructive global order. Friends, this convention today is going to go a long way in shaping our thoughts. I'm very much sure. There are so much to learn and then to assimilate the best practices around the world, and that leads to the capacity building is one for all and all for one, and we go on proceeding further. There are rapid changes these days coming up, including as recently a couple of weeks back, the Bar Council of India has started to open up as regards the involvement of our foreign friends into the system of proper advising the litigants or the person in need of advice. Of course, the things shall be taking their own shapes, but it's a beginning and it's going to go a long way, and ultimately making, I could say for sure, that India is a hub for international trade, commerce and arbitration too. Friends, India has already established several institutions to promote international arbitration, such as Mumbai Center for International Arbitration, the Delhi International Arbitration Center, and the International Center for Alternative Dispute Resolution. These institutions have provided platforms for resolving international disputes and are becoming increasingly popular. I'm sure in the coming days we are going to have more of the institutions playing their important role in combating the emerging issues of cyber crimes and technological and out of those technological developments. Friends, the learned, since you have several sessions to go, I won't be standing now between you and those sessions. The learned Attorney General for India, as he was introduced, and rightly he proved also a great poet in his own rights. Frankly speaking, the poetry is not my forte, and I can only recite or try to recite out of a few things which we learn. I was tempted to take note of and to share now today with this audience to underscore my points which I indicated in the famous poem of Gurudev Rabindranath Tagore, where mind is without fear, and I just recite it. It goes as follows: where the world has not been broken up into fragments by narrow domestic walls, where words come out from the depth of truth, where tireless striving stretches its arms towards perfection, where the clear stream of reason has not lost its way into the dreary desert sand of dead habit, where the mind is led forward by thee into ever-widening thought and action, into that heaven of freedom, my Father, let my country awake. Tagore's vision for India can and should be extended to encompass the entire world. Narrow domestic walls must be broken in favor of a shared global identity that promotes tireless striving and ever-widening thought and action. Thank you so very much, friends.
Before I give my vote of thanks, we have a surprise. We have members from the Udaipur Bar who like to felicitate Honorable Mr. Justice Dinesh Maheshwari. If I can request them to come on the dais, please. Just for background, His Lordship is from Udaipur, and the bar members have specially come all the way to felicitate him. Thank you. So to conclude this inaugural session, I like to give my vote of thanks to Honorable Mr. Justice Dinesh Maheshwari for gracing us with his presence today, giving the impetus to the convention, and on a sweet note, ending it with Gurudev's few lines which inspire all of us, and we are all so obliged that he has given the necessary strength and the starting for all of us in the next 2 days to enjoy this convention. So I thank him from the bottom of my heart. I also thank our Attorney General for his such an insightful and well-researched address that it was a learning experience for me personally, and I'm sure all of you have taken benefit of it. And also mixing with his few lines of poems that he shared with us. So I'm so thankful for that. I also like to thank our President, Mr. Prashant Kumar, because he's the one who conceptualized this convention. And this is the first convention, the New Delhi International Rule of Law Convention, which we hope to have every 2 years. So we want to go from strength to strength. And it is thanks to him single-handedly that all our foreign friends could come on such a short notice personally. So thank you so much. I'd like to thank Mr. Shyam Devan, President-elect of Law Asia, and on the sweet note that he has started the convention, the mango has become the theme. In India, we also have a word, Mango Man, which is Aam Aadmi. We are all Aam Aadmi, and we thank him for that. And we thank our President-elect of Bar Association of India, Mr. Amarjit Singh Chandiok, who has supported us for setting up the convention in every way, which way we wanted his help. He was always there day and night. So thank you so much, sir. Now, I especially like to thank our international delegates, our friends who have come from all across the world. And I know it is going to be a bit lengthy, but I need to name each one country that has come from the 20 that have been named. So if you can just bear with me, I like to thank them. I like to thank friends from United States, Israel, South Africa, Azerbaijan, Brunei, Singapore, Uzbekistan, France, Malaysia, Russia, Italy, Belgium, Japan, Honduras, Cambodia, Taipei, Dubai, Germany, Nepal, Sri Lanka. Thank you so much, each one of you. Your presence has made this convention, the beginning, the starting, such a success. And I'm sure each one of us will learn and exchange thoughts and exchange ideas with them and take every opportunity to give our host, as we in India, we like to host our friends, make them feel comfortable and learn from them and exchange ideas. And I also like to thank our friends, our senior advocates, Advocate General from Jammu and Kashmir who's here, Additional Solicitor General who's sitting behind, but he's here, specially taken time out. Senior advocates I can see in the back, in the front who have taken time out. Mr. Mohit Mathur, President of Delhi High Court Bar Association, who's here, and so many other friends, each one of you actually. Thank you, thank you, thank you. Because of you, this convention is the success that we are going to see. Thank you so much. I'll just like to conclude now that we have a tea break now because our program was supposed to finish at 11:30. So I'll just request if after this we can have a quick tea break and then come back. The session starts from here only in this hall. Thank you so much.
my colleague Rachna Srivastav. We have 4 distinguished speakers apart from Rachna, and we'll set the ball rolling. We're running because of the enthusiasm in the earlier session and the presentations, a little over time. So I'm going to request each of the speakers to address us for about 12 minutes, if that's fair. And then if there's some further time which is available, we will take questions and interventions from the audience and from the delegates. Thank you very much for joining us. I had a little problem with the pronunciation. Is it Jorg? Okay, Jorg has also now joined us. So I'll turn this over now to Rachna. We thought we'll interleave the speakers, the home-based speakers, the speakers from India, with our guests and international delegates. So we were thinking, I'll leave the order to Rachna. She will introduce each of the speakers with a short reference to the bio, and then I'll request each of the speakers as their turn comes to address us with their experiences for around 12 minutes. Rachna, over to you.
Thank you, Shyam. Good afternoon to you all. The working session 1 is about the topic placing humanism and values and principles of the rule of law at the core of global and national governance in order to achieve the ideal of one earth, one family, one future. That is the theme of our convention also, Vasudhaiva Kutumbakam. The first speaker that I am going to invite is Shri Vikramjit Banerjee. Mr. Banerjee is the Additional Solicitor General of India. He is the senior most but the youngest Additional Solicitor General of India. Mr. Banerjee was also previously Advocate General of State of Nagaland, and he is alumni of prestigious Law College of Bangalore. Mr. Banerjee has many feathers, but he said don't count all of them right now, keep it for later functions. So over to Mr. Banerjee.
Thank you. It's a pleasure to be here. It's an honor to be here. And, it's a wonderful audience and such eminent people. It's an honor to address all of you here. I have the presentation which I want to make is, broadly the topic is humanism and values and principles of rule of law, and how they can be part of the national and global legal order. There are 2 points which I think which needs to be addressed. And before I say this, it's my sort of personal views on it. It does not in any way reflect upon what the government holds. So that's the caveat put in. According to me, humanism should be a part of rule of law. It should be a part of global governance. And there can be no debate on that. However, and these are some of the questions which need to be flagged. What is now happening is with programs and computer programs becoming sentient, that is, being able to understand the world, react to the world, almost think for themselves with artificial intelligence. The question of bringing humanism back into rule of law becomes a difficult process. Information technology itself is something which, the challenges which face humanism today to be at the forefront of rule of law in the global scenario are manifold. One is because of the presence of social media, it has enabled, in many ways, all of us to express our views very freely. It has also ensured that there can be actors who may use this freedom, or should I say misuse this freedom, in order to influence the course of action in different societies. And they may not be in your country, which then actually impacts the society in which we exist. Second, this has also led to responses from the state to carry out greater and greater sort of surveillance, to ensure that the freedoms which are guaranteed as part of rule of law and liberties which are enshrined in rule of law are not misused. This is a challenge like no one else. And ironically, while we today discuss this entire question of humanism and inserting humanism into rule of law, and which we think should be given, it is becoming more and more of a challenge to bring back humanism to a process which is being taken over by, in many ways, by mechanisms and artificial intelligence and the internet. The space of inserting humanism into the rule of law is becoming lesser and lesser. Another aspect which I want to flag is the question of use of biotechnology. As we all know, that there have been great advances in biotechnology, which has led to, for the want of a better word, for some sort of experiments which have resulted, which or can result in consequences which are very extensive. Last few years, we've been all shut at home at certain points of time, and our liberties have been greatly curtailed because of the nature of a global pandemic. Now, the input of science into this global pandemic and whether science itself was responsible for this is another question. And whether such science can be used to disrupt societies is a further question. The response of the state, therefore, has also been to cut down the liberties in order to protect the health of the society at large. So ironically, while we are today discussing humanism and we live in a globalized world, and where we would have expected that there would be humanism right at the forefront of any globalized world, we see that globalization, ironically itself, is throwing up challenges to bringing humanism into the process as a part of governance. Second point is, when we discuss the questions of rule of law, what is the rule of law? I think that's a fundamental question, which I think everybody was discussing, but no one was addressing. Rule of law, according to me, and the way it exists today, where it's defined today, exists out of certain values which arose at some point of time in the West. And West as in Western Europe, and whatever arose out of that. Now the conflict of that is the world has changed, the world is changing. Most people of the planet live in a non-Western world. The balance of power is anyway shifting. And for a rule of law to be truly credible, it has to encapsulate values which arise out of the non-West. For the want of a better word, I'm using a shorthand here. On one hand, this entire concept of rights and privacy. On the other hand, this entire concept of social order, of having order, and of the basis of having duties in societies. Now, for rule of law to be truly universal, it will have to balance these two concerns and not be taken away or believe that the objective of rule of law means only to create a society which exists in certain parts of the world. It has to be more diverse. Interestingly, I will just quote, two very famous legal philosophers who address this question. One is, I don't know how many of you have heard, is Alasdair MacIntyre. Alasdair MacIntyre is one of the foremost legal thinkers of the 90s, and he wrote a very famous book called After Virtue. In After Virtue, he basically proposed and very wonderfully wrote that there was, before the 19th to 20th century, there was no approximate word for the word rights in any non-European society, and how the whole conception of rights was actually thereafter brought into the lexicon of law. Now the question is, does it mean that societies were not fairly governed? Does it mean in India, where democracy has existed for 5,000 years, and it's very old, and whereas civilization has existed for 5,000 years, and recorded democracy or democratic institution existed in recorded history for nearly 3,000 years, did we not have our conceptions of rule of law? And in those conceptions of rule of law, which were primarily based on conceptions of duties towards one's society and of having an ordered society, is that antithesis to rule of law. Now, another very famous, here it's very relevant to quote another very famous Indo-Spanish theologian, very famous theologian called Raimundo Panikkar. Raimundo Panikkar wrote about, he had a very famous article published in the UNESCO publication department called Diogenes. In Diogenes, he wrote a very famous article called Is the Notion of Human Rights a Western Concept? It's very oft quoted. Anyone who's worked on that area will know. Panikkar theorized that in Indian, and he wrote it from a uniquely Indian perspective because he was both knowledgeable in Christian theology as well as in Indian philosophy. And he wrote, in India, possibly the concept of dharma, of duties, was another way of governing society, of organizing society, and for running society. I would only propose that if we are going to truly have a rule of law based on humanism and based on a global order, then for it to be truly and universally acceptable, it has to incorporate concepts and ways and methods of organization, not only of certain parts of the world, but across the board from various different societies, especially in the non-West. Now, I have to flag an issue which was discussed, and I think that's also important. A lot of stress on independence of judiciary has been stressed as part of, as very important and integral part of rule of law. Independence, complete, absolute. According to me, both in history of even Western constitutional law, as well as in culturally, we have never treated any wings of government as silos amongst themselves. Now, and we have never treated that a certain wing of government will be completely independent of each other. according to us, unlike, again, and I'm not deriding it, certain experience of history which happens in certain Western European governments and possibly in the United States of America, we have always had a history, whether it be in the parliamentary system that we have today or whether it be Indian civilizational background, that all wings of the government actually work together to have a virtuous society. And it is important that when we talk of a rule of law, we should be able to bring all these influences together. In conclusion, and I'll conclude because we are all running short of time, when we were young and when I was in law school, it was a given, when I was your age, it was a given that, and I was there in the 1990s, it was a given that the best form of governance was free market, that we would have a future where there would be free markets and which would lead to a prosperity for all. We also believed strongly at that point of time, and we were like at the forefront of it, that the only way to have a successful society is to have unlimited rights. Unlimited rights. 30 years later, and when I'm 50, and when I got into it when I was 18, the world has changed, and experience has taught us that that may not be completely true. So learning from experience, it is important, according to me, that we view the world differently. And in this changed world, as well as the experience which we've had for 30 years, I think it's time to reevaluate what constitutes the rule of law. And if we are going to have conceptions of humanism and rule of law inserted into as a broad framework for global national governance, it is key and important that we rethink these issues and for once be inspired from, for the want of a better word, I know it's controversial, the civilizational backgrounds that we come from. Thank you.
Our next speaker is Dr. George Menzer. Dr. George Menzer is the Secretary General of International Bar Association. Apart from being an eminent lawyer, he is also a teacher. Let me inform our foreign delegates that in India, the teachers are placed on a higher pedestal than the God. So we welcome you, Dr. Menzer, please, for your address.
Yeah, thank you very much. It's a great honor to be here in India. I must confess this is my first time, but it will not definitely be my last time. Thank you for having also the International Bar Association part of this great convention. And before I start my little contribution, I want to send the highest regards of the President of the International Bar Association, Mrs. Almudena Medvedev, to you. She herself could not make it, so I took her place, and Prashant, I'm very happy that you reached out. Well, as you see and as you hear my accent, I'm somehow from Western Europe, from one of those old countries. I'm German by origin. I live in a different society. My wife is from Romania, so I, since 22 years, live in Romania. Therefore, I see changing structures and changing societies. I've experienced it myself. I cannot abstain to disagree a little bit with my learned speaker before me. I believe, A, humanism is the basis of rule of law. I think without humanism, we don't have a rule of law. B, I agree that, yes, we have to learn from all cultures, and every culture has developed over hundreds of thousands of years, of the last thousands of years, into where we stand as a global community nowadays. But we also have to, I think, maybe I misunderstood you, be very sensitive to the notion that the society at large should or could be more important than the individual. I think humanism, for me, from a Western country, from a Germany which experienced what it means, how quickly rule of law can be misused and turned into tyranny, the protection of the individual person, of his dreams, his rights, and his beliefs, like we here have in India, which was mentioned before, with so many different religions, is the basis of the rule of law. We cannot sacrifice the individual liberties and right to develop and to live a life how he or she or it wants to be considered just for the common good of society. Actually, there is the main struggle between the individual interest and the society interest, which we have to solve by applying the rule of law. Now, I'm sure that we will have an interesting discussion later on. Let me go back to what I wanted to say. As you know, throughout history, the thriving of civilization was always connected to the rule of law. Individuals, institutions, and governments need to have the certainty of the rule of law, that the law is equally enforced and applied, because otherwise it cannot thrive, it cannot develop. That is a guarantee that our society and us individually can develop and contribute. I'm not sure if I should quote a former British Prime Minister in India. I leave that to your evaluation. However, Margaret Thatcher, who is probably quite a strong woman at the head of her time, said once, "The legal system we have and the rule of law are far more responsible for our traditional liberties than any system of one man, one vote. Any country or government which wants to proceed towards tyranny starts to undermine legal rights and undermine the law." And as you have seen and was mentioned before, the World Index of the Rule of Law by the World Justice Project has been really reporting and looking at this for years, but has, especially in the last 5 years, seen a strong decline in many countries. And since I'm the Secretary General of the IBA starting in 1st of January this year, our organization, myself, I have received from 3 bar associations over the world already almost reach out, some cries for help because they are under pressure, our profession is under pressure. I find this very alarming. Why this all happens, it's very hard to say. Maybe it's exactly what was mentioned before, not only by my colleague here on the panel, but in the other interventions. It's the struggle of finding out where we as mankind really stand and what we really are striving for. What the rule of law means, at least to my belief, is A, the equality before the law. As you know, in the Indian constitution that was so prominent, reflected upon here, is one of the best examples. In most constitutions worldwide, as much as in the Universal Declaration of Human Rights, it's recognized that all individuals should be treated the same manner by the law, and all individuals are entitled to equal protection against any discrimination and violation of their rights. This seems to be quite simple, and I think this principle we all know, but maybe it's the most disregarded. And maybe it starts already in our childhood, because we all learn at home. I have 3 little boys, just came back from a short vacation with them, and we were fighting every day about the use of the mobiles. So there was a rule. Daddy said and Mom said, no, only after you have read some books, and only once you come back from skiing, and we do some other issues. Obviously, the little boys, they sneaked upstairs, searched for the iPhone. When I hit them, they took out the iPad and made Find My iPhone, so somewhere it beeped and they were all running and trying to get around this rule. So we learn in a young stage sometimes to not obey by the rules that are given, and therefore we probably run in the difficulty also as societies that it's quite hard to adhere to this principle, to adhere to rules and regulations, because it's not only how they are set up at the beginning, it's especially how they are lived. And I think here our profession, the young lawyers in the room, but also us more senior lawyers have to be there an example. We have to live up like the Indian Bar Association does, by our own ethical standards, by our own rules in everyday life, and as hard as it is in our actions. Now, let's look at legislation. That is often a very complex undertaking. We know how politicians make laws. They are driven by votes. They are driven by their needs to be re-elected. They are driven by their beliefs and by their own ideas, which is all good and is especially, I think, a good expression of democracy to try to find the best solution for all. However, the legislative process is sometimes not quite transparent. It is done by us lawyers, by us politicians, as we today talk to ourselves. I think we need to be there aware that we have to explain the legislative process much more beyond the legal profession, beyond the universities. We have to educate the wider public and make them understand that this is also their duty to participate, but also their right. Nemo sensator legem ignorare, nobody is thought to be ignorant of the law. So just that you don't know the law doesn't really protect you. You cannot go in front of a judge and say, well, I'm so very sorry, I didn't know. Well, yes and no, because I think what I said before, the transparency and publicity of law is one of the great and important ingredients of the rule of law. Only if society, if people understand what the rules are, they can adhere to them, they can obey, and they can also share and maybe criticize. So I think we need to ensure that the judiciary has enough resources to administer the law, but that the general public also can get access to law. Pro bono projects are all over the world and also in India active. Also the International Bar Association has a pro bono committee and different programs to foster this. But we must understand that also in this room that we as lawyers are privileged. A, we studied the law. B, we are the middle class, so we are educated. And C, we therefore can also access to protect ourselves, our families, our friends, our clients, the system of law. Is that really true for everybody? Is that not very important that everybody really understands what rights he or she has? So there is a point where public needs more clarity and more involvement also in the legislative process. I know that also in India, like in most countries, at least democratic countries, law initiatives are publicized before for debate. I come, as I said, from Germany. There the process is quite transparent. In Romania, there's also public adherence where I practice, but sometimes the government publishes it on a Friday. You have theoretically 7 days for the public to give a comment, and then it's law, which obviously, from my perspective, is not good enough. Therefore, it's also about community. Because if we strengthen our communities, if we really reach out, if on the village level, on the city level, we involve people in the rules and regulations of that smaller environment, they will learn and they will be feeling responsible, and therefore they will get the taste of the rule of law. Obviously, the independence of the legal profession and judiciary, which was mentioned today, is very important. What does it mean? What does it really mean, a functional judiciary? Is it good enough to be saying, well, we have a big backlog, that's it, but it's good that people are patient? I would challenge this. I think a society like the German society, Romanian society, maybe like the Indian society, needs not to accept this. It needs to really say justice can be only administered if a court proceeding takes not longer than 12, 16, 18 months. Otherwise, it loses its impact because the moment of trouble, the moment of infractional behavior to the sentences or to the ruling is just too long. People will either give up and therefore distrust institutions, or they will partially not even start to pursue their rights as individuals. 。 The judiciary obviously has to be independent, and also this was mentioned. I was very proud to learn about Article 32 of your constitution, which levels also the access to the judiciary to a basic right. And I think it's true. Here, Encyclopedia quotes the following: the more powerful the actors whose interests are at stake, the greater the need to protect the independence of the court from that actor. If both sides of the disputes are powerful, however, that symmetry of power may provide part or all of the necessary protection. What does it mean? Especially referring also to your technology structure and to the international global world we are living in. It means that if only one party to a case is very powerful, the chance that this, be it with money, having the best lawyers, be it with political influence, having the best friends, be it just because they have a long breath to live through a long procedure, will probably prevail, even though that doesn't mean that justice is administered. So therefore, we need to make sure that the judiciary stays really independent. And also here, I'm sorry, I disagree a little bit with my learned colleague in the speech before. I'm sorry, I'm German. We are sometimes always having to say what we think. Not English enough, maybe. Because I don't think that we should mix institutions. I think the rule of law and the defense of the rule of law, and I'm sorry if that is maybe a very European perspective, lies in especially the independence of the judiciary. It starts already, that's a personal quote now, with a question. And also in Germany we have this, that sometimes former politicians are elected to be Supreme Court judges. I don't know. Most of those colleagues are great and independent, but I think we should be very careful, because otherwise we will not be able to keep count. And as I said, I don't like it, but as I said, I'm from Germany. Also the Nazis in the Second World War used the law, but it was rule not of laws or on rule by law. And I think we all saw what happens and see it every day in other parts of the globe as well. So from my perspective, those pillars I just mentioned are the ones that promote the order and the support of the rule of law. Education towards non-discrimination, respect of human rights, zero tolerance of corruption, abuse of power are the basis of what we have to strive for. And I can gladly report that the International Bar Association has the rule of law as one of the major goals of a strategic plan to not only reform our own organization, but to reach out and to become even more important with the bar associations around the globe. And we have also 3 pillars of this: access to justice, independence of the legal profession, and enhancing understanding and respect for the rule of law. I think we have to increase awareness of those principles. We have to lower the costs and into the roots of justice. And as I said at the beginning, we need to support the people who really don't have access to this decent justice. To develop an understanding of nature of the attacks against the legal profession around the world is very important. Bar associations are under not direct attack sometimes, but they get certain rules and regulations they have to obey to, and therefore they have also the difficulties to overcome and to probably sometimes formulate their real goals. So overall, I'm very optimistic because I think we as lawyers are exactly the ones who protect the rule of law, who can teach the rule of law, who can reach out, and I would just inspire all of you, especially the young colleagues. I learned that you all have to wear black suits in court, so that's why I see so many men and women in black. Go out there, reach out, and form exactly this. Be proud to be lawyers, show the community you live in that what it means to be a lawyer, and that the rule of law is in everybody's hands and is protecting everybody, individually and as society at large. Thank you very much.
Thank you, Dr. Menzel, for your very insightful address on the topic. And I'm sure your partially dissenting view will also give a different perspective on the issue. May I now invite Mr. Prashant Kumar, President Bar Association of India. Mr. Prashant needs no introduction. He is very well known to, I think, the entire audience, except that, but in addition to that, he is a past president of the Law Asia, and he too wears too many feathers in his cap. If you start counting all those feathers, the session will be concluded. So over to Mr. Prashant Kumar. Please do come.
Thank you, Rachana. I have already spoken during the inauguration, so I'll try to be as brief as possible. Friends, along with the program, there is a message of the senior-most Supreme Court judge, Justice Sanjay Kishan Kaul, at the last page. And there, in the second paragraph, the last sentence, I invite your attention to. It says, the rule of law is the accepted norm of all civilized societies that protects the sanctity of life and liberty. I think this one-line definition presents the essence of the rule of law and humanism, because ultimately everything which we encapsulate under the umbrella of rule of law leads to protection of sanctity of life and liberty. Rest all are components, how you operate them, in what manner, through what kind of governing systems, because world over there is this lot of different varieties of systems of governance, the way the affairs of the government is conducted, but essentially the goal and objective of any society, any state, which inheres in the rule of law, is protection of life and liberty. So here, I will just try to bring one more dimension. And especially, it is there at the level of the nation states or countries, but we find it more and more powerful, manifestation of it in the international or global concept. That is that lot of power in international arena is concentrated in the hands of private corporations or the multinational corporations. The United Nations, recognizing that, started a drive to, and especially with the organizations which talk about rule of law, law societies, bar associations, to talk about the business and human rights. Now there can be a narrow conception of it, that each business operating its own field has to respect human rights of the labor which works there, human rights of the community it supplies goods and services to, and if it is creating value out of natural resources or carrying manufacturing processes that create environmental damage and pollution, how to mitigate that. So all these come under the umbrella of business and human rights. But let's try to take it a step further, and we say that business or private power and the rule of law. The examples are that we faced this in 2006, 2007, even in 90s, and now we are all talking about a recession, a global recession. And the genesis of global recession lies in the lending practices of the banks, the global huge banking institutions. What the banks do, the banks take money or value from people, whatever manner they are incorporated, and then they make the decisions to lend them to corporations, to others. And the globe has suffered twice, and we are looking at a third iteration of it from a disaster, from an anticipated disaster, that the banks are going to face challenges. It is the taxpayers' money, which country, which jurisdiction is utilized to write it off. So they are a category of professionals, a few bankers, few businessmen and all, who overutilize the capital, utilize it in imprudent ways. There are other ways it is impacted, but ultimately what happens that when the global recession takes place, everybody's human rights suffer, and it is the poor countries who suffer the most. So that's why we have to now start thinking of rule of law in a broader context, that the principles and core values of rule of law should apply to all institutions, all entities, all individuals who are empowered to make decisions which impact others, not in just one part of the globe, but maybe everywhere. How we have to construct the rules, disciplines, and a global governance order that we expect that in all these processes, the level of prudence, the balancing of individual objectives to make profit is an essential drive for human progress. We don't quarrel with that. But how to balance all these things and what has to be the level of oversight? Now, banking, fixing interest rates, LIBOR, other things, all are done by amalgamation of private players. And the power they exercise can impact every single human being on earth. But despite that, we don't have even a conversation how to control, how to regulate, how to make that power accountable. We talk about global warming, we talk about impending environmental disaster. Again, it is not just the practices which the governments adopt and others. It is also the way the international business is structured. And one of the most tragic manifestations of the failure of rule of law globally, which one can see, is in those countries in Africa and Asia, which are endowed with a wealth of natural resources, with which their generations can survive, but they live in abject poverty, want, disease, and death, and strife. So how all this plenty, because of the lack of rule of law, because of the lack of systems in which, because it is not just that those countries are incapable of governing, they don't have a culture of rule of law. Somewhere it is also that how the businesses and others permeate and influence the governance systems and the government systems that lead to implosion of the rule of law and the consequences which are so tragic for the humanity, not just in that country, but when it becomes a template in the continents. So that is why, my friends, when we say placing humanism and values and principles and these core values, we have to start thinking beyond, much beyond what we have been thinking, because the globe is coming together not just because of travel and all, but due to trade, commerce, economic integration. But that ought to take place in a manner that integration is beneficial to all, that integration respects all the rules, it in fact respects the core values of humanism. This integration is most welcome, its progression, its evolution, but we must have rules for it. We must have systems to govern it. And that is what we want, that New Delhi should become a clarion call every 2 years for us to come together, sit together and see What are the institutional gaps? What are the ideas we have to bring into play? Because as men of law, who know how to apply, interpret, and make laws, we are very well equipped to carry out this exercise, and we will fail in our duty if we don't do that. Thank you very much.
Now, our last speaker is Mr. Alexei Klishin. Mr. Klishin is member of Presidium, Chairman of the Commission on Legal Framework of Modern Integration Process of the Russian Federation. Mr. Klishin is also First Deputy Chairman of the Federal Council of Committee for Legal and Judicial Matters. Mr. Klishin specializes in the sphere of legal regulation of foreign investments, etc. He is author of many publications in civil law, tax law, and other international public law. Mr. Klishin is also founder member of the BRICS Legal Forum.
Yeah, thank you very much. I asked my colleague to shorten the list of my positions, but she didn't manage to do that. Thank you very much. Thank you, dear colleagues. First of all, I want to express our gratitude being invited to this convention, which is very important. Our president, the president of our Association of Lawyers of Russia, was supposed to be here, the former Prime Minister and the Minister of Justice, Mr. Stepashin, but due to some medical problems he didn't manage to come, but he's sending his gratitude and greetings to our Indian colleagues, and particularly to Mr. Prashant Kumar, he is expressing his support and expecting, the fruitful work and results of our mutual work. I refer to previous speakers, and in a way I'm continuing the speech of the previous speaker, Mr. Kumar, regarding a different understanding, different interpretations of the concept of rule of law. The lawyers are asking each other what is rule of law and answering, and the answers seldom coincide. Anyway, what is important is that a variety of cultures and civilizations is one of the key features of this modern world. And delegates from the countries of Africa, Latin America, Asia, and Europe are present here in this conference hall. Each of these countries has its own history, traditions, culture, values, way of life, and most importantly for us, its own legal system. This is why the reality of our day is the formation of the multipolar world and the legal order based on the principles of justice and multiversity, and as well as on the equitable dialogue, balance of interests, and universal rules of international law enshrined in the Charter of the United Nations and the Declaration on Principles of International Law concerning friendly relations and cooperation among states. The diversity of society forms and legal systems must be acknowledged and accepted as a certainty instead of getting into disputes over one type of such systems being better or worse than the others. Our role as lawyers is not to identify problems, but to find compromises and equitable solutions for the benefit of mankind. Our common goals include protection of human rights, elimination of racial or ethnic conflicts, fight against discrimination, violence, and crime. We should promote equal access of the nationals of our countries to the public goods, such as high-quality health and education, and should also endeavor for the reliable protection of all population categories, including the most vulnerable ones. This process requires our mutual cooperation based on mutual trust, respect towards each other's interests, observance of universal rules and values established at the time of their acceptance by the global community. International organizations, in their turn, are designated to provide universal negotiation platforms based on the principles of true multiversity, as well as to protect the Charter of the United Nations and the goals enshrined in it. In real practice, we can see that one group of countries attempt to impose its legal concepts and values to other groups of countries without consideration to their historical and cultural characteristics. We can see now that the modern system of international law is undergoing a test of strength. Approaches aimed at undermining the actual foundations of international law and first and foremost state sovereignty pose a major threat to the system. Some countries, mostly Western, intensively inculcate the concept of rules-based order as an alternative to the international law. They justify it by the alleged adherence of all countries to the uniform rules and values, the substance of which is not entirely clear, yet it is obvious that the values and interests of the proponents of this concept and the rules designated to ensure the observance of these interests are interpreted as such rules-based order, being a counterbalance to the collective rules and values based on the UN Charter. An example of practical implementation of the rules-based order is a set of resolutions on the establishment of various attribution mechanisms within the executive bodies of international organizations, such resolutions being pushed through by the controllable majority in violation of the statutory instruments of these organizations and the fundamental principles of the United Nations. These attribution mechanisms are vested with quasi-investigation and quasi-prosecution powers in order to make certain states responsible for the illegal acts allegedly committed by them. We know various examples of this attribution mechanism to be established. Considering compliance with international law to be a key factor of stability in the international relations, we stand for the collective consensus-based decisions and for the international legal order that has no alternative as the order based on the UN Charter and the ensuing principles and rules of international law. Global problems cannot be solved on the basis of unipolar approach and double standards. However, we can see the attempts to solve them on such basis in the situations related to religious freedoms, where the autonomy of states and, in some cases, regions within states must prevail. As for the international law, its provisions are interpreted by some states in their own favor. The mechanism of unilateral coercive measures, so-called sanctions, is being applied in violation of the rules of international law and the provisions of the UN Charter. The purpose of these sanctions is to disrupt the national economy and force one state or another to change its policy for the benefit of the initiator of such measures. Unilateral sanctions do not only deprive the affected states of the ability to receive international humanitarian aid, but also have a very negative impact on the situation in their social spheres. The issue of damage caused by the unilateral sanctions has been discussed in the United Nations, in particular at the General Assembly, where the resolution on unilateral economic measures as a means of political and economic coercion against developing countries is adopted biannually, and the resolution on human rights and unilateral coercive measures is adopted annually. Such restrictions are incompatible with the idea of bona fide compliance with the norms of international law, including the principles of cooperation, sovereign equality, and non-interference with the internal affairs of states. Moreover, the application of unilateral coercive measures that are not based on the international law in the absence of the relevant resolution of the UN Security Council, or that are additional to the measures taken by the UN Security Council may be contrary to the goals and objectives of the Council's resolutions and may undermine its competence as a body, ensuring international peace and security. The Association of Lawyers of Russia, a public organization with more than 35 members, has its offices in all constituent territories of the Russian Federation. Representatives of all areas in the legal profession, attorneys, legal scholars, corporate and privately practicing lawyers, judges, public prosecutors, investigators, notaries, civil servants, as well as lecturers and students of law universities make up its membership. We stand ready for the honest and mutually beneficial cooperation with the international legal community in order to enhance the rule of law as the foundation of the multipolar world where the rules of international law are observed and to withstand the threats to the security of mankind. Thank you very much for your attention.
May I sort of thank each one of the panelists over here to my left and to my right for having really made very thought-provoking presentations, full of ideas, full of points and counterpoints. And I like the fact that there was this debate and discussion, because I think it's going to stimulate us for the next set of business sessions and discussions. So I thank each one of the panelists, and may I request all of you to join me in commending them in the usual manner. I think just to end, I suspect we're beyond time. Yes, we are, by almost 17 minutes. I want to also thank them for their brevity, conciseness, and very, very sharp points, because we've hauled back a little bit on the overreach in terms of time. I think I'll just leave you with a thought. I thought I might sort of summarize it, and I thought, is there some time to take questions from the floor? But I don't think that permits. We're sort of 20 minutes nearly past 1 p.m., which was the lunch break. So I'll leave you with this thought. I'm not very sure as to what rule of law exactly is in terms of philosophical definitions. But I think I have a reasonable sense that it certainly comprises, number one, fairness. It certainly comprises predictability. It certainly comprises inclusiveness to ensure that no one is really left out. It certainly includes, in my assessment, a degree or a machinery which is accountable. So these are features which ought to be present. Please reflect on whether in each one of our systems and societies we have attained these goals, whether we continue to fall short, and whether we can improve them. And I think if you do reach the conclusion that yes, there is scope for improvement, I suspect that in each of our communities, large and diverse as they are, we need institutions. If we are dependent on individuals, I think the system has failed. And therefore, rule of law in the context of humanism will have to be delivered at the end of the day by strong and robust institutions. With that thought, I thank each one of you for attending this session, and there will be, I'm sure, lunch which is served, to be followed by the next working session which begins at 2 p.m. So thank you all, and please join me in a round of applause. Yes, please. So we have